in their favor and said that the risk contribution doctrine was retroactive, violated a series of cases, Eastern Enterprises and so forth, and threw the case out of court. And Judge Edelman, who had a number of other cases, ruled that the case was completely constitutional and was a rebuttable presumption that the companies could fairly dispute. Okay? I appealed the Gibson case to the 7th Circuit Court of Appeals. Every other case that had been filed was stayed. 3 or 4 cases in state court and about 160 cases in federal court. Senator Grothman does not know what he's talking about. Many of these cases had been filed well in advance of Act 2, well before Act 2 was ever contemplated. We went down after a year of briefing to the 7th Circuit Court of Appeals on January 9th at 9:30 in the morning. And we argued whether or not risk contribution violated the Constitution of the United States, whether or not it violated the substantive due process rights of the 6 defendant manufacturers. Okay. We drew a 3-judge panel. That argument was over at 10:30 in the morning. The lawyer for Sherwin-Williams makes a phone call and informs us that, well, I retract that what I just said. The lawyer for Sherwin-Williams informs other counsel that they got something in the hopper, that something's going to happen in the State House. 2 hours later, Senator Grothman's office calls over, sends an email, which is in your drafting packet, to the Legislative Reference Bureau, instructing them to jacket the bill. The bill was drafted on December 22nd, initiated on December 22nd, and I believe it was put in the hopper so that the 6 lead paint manufacturers had it in their back pocket, depending on how they saw the litigation in Chicago going. And we never know how a court like the 7th Circuit Court of Appeals is going to rule in any given case. I walked out of the room optimistic, but I'm an optimistic person. I'm optimistic that you are hearing my plea for justice, sir. And I'm optimistic that these children will have some justice someday. And so I was shocked the next day when I found out that this had happened, because the lawyers, including Mr. Jim Murray, who is scheduled to testify here, have been litigating this case against me. He represents the National Lead Company, the maker of the Dutch Boy paint. Sherwin-Williams wanted to cover the earth with lead paint. And I want to give you some basic facts here. And I hope you give me a few moments, because we'll consolidate the testimony so you can hear our side of this story. Okay? But I think it's important to put this in perspective. Okay? Sherwin-Williams, so far this year, as of this point, as of the end of the 3rd quarter, netted $6.7 billion in sales. This is a corporation that put in its 10K form, year after year after year, that it did not face any adverse consequences as a result of litigation related to lead. Okay? Every one of these defendants has represented to the Securities and Exchange Commission that lead paint litigation does not adversely affect their business operations. All right? Now, I got to tell you, when I found out about this, I called up Lexis and Westlaw and I looked in all the books because I wanted to find a case about retroactivity of this type. Okay? We got Matthews, we got Richards, we got all these cases where the question is whether retroactively you can extinguish vested rights in cases that have not been filed. Okay? But here, we got cases that have been filed. And the one piece of Senator Grothman's testimony that I appreciate is the fact that he had enough candor to sit here and tell you this case is about the 173 kids. That's what it's about. It's not about anything else. It's about those 173 kids, some of which are here today. These are the kids who could get here with 24 hours notice. Okay? And that's what this is about, because Act 2 extinguished, abrogated risk contribution prospectively for cases filed after its effective date. And Act 2 purports to relate back to cases that had vested injuries before its enactment date. If those cases are filed afterwards, under Act 2, they're out. If Act 2 holds up. Okay? But Act 2 and the rules, I mean, I think the analogy to the football game is right spot on. Okay? Because these cases, 164 cases were filed to preserve the rights of children that I represented. I had an ethical obligation to file those cases because I represented those children and their rights were about to be extinguished. So I filed those cases, as any good lawyer adhering to the ethics of the profession would do. Okay? And so let's go back to risk contribution. My heart was contorting as I sat here and listened to Senator Grothman's description of what risk contribution is. I'll give you a more apropos example of it. Well, let's back up first to lead poisoning and how it happens, because you have to appreciate that this is not a question of a linear relationship between an event, a sale of a bad product, and sometime later an injury. That's not what lead poisoning is about. This is not what happens here. If you slow this clock down and get medical testimony and find out what's really going on here is, in a house you have windows. And those windows open and close. And when those windows are painted with lead paint, the surfaces abrade and create dust. And cumulatively, over time, the child ingests that lead. By crawling around the floor and doing what children do, they play. They get their hands wet, they put them on the ground, the dust attaches to their hand, the dust gets in their body, and it gets into their blood. And over time, it accumulates. And it poisons them. And it causes serious learning disabilities, attention deficits, and many other problems. So this, and you have to, in Jasmine Clark's case, we have spent hundreds of thousands of dollars between my side and Jim Murray's side doing analysis of the paint chemistry in the homes in which she was poisoned. And we found that in some of the rooms where the paint was, you have as many as 80 layers of paint applied over 75 years. Right? This is not the paint of one manufacturer. This is a cesspool of all of the manufacturers. And that lead reformed an indivisible toxic threat to these children. And just being children, they got poisoned. So the analogy is to, I say, for example, 6 companies, factories around a body of water producing the same chemical, they contaminate the water. You drink some of that water, you get injured. How are you supposed to tease out who did it? Under the law, we have this idea that developed back in the 1920s in the famous case where there are 3 hunters hunting, and they shoot at 2 of them shoot at the same time, and one injures the hunter in the middle. It's called alternative liability. And the court felt it was appropriate to require those hunters to exculpate themselves as they could, because the hunter who was injured couldn't prove who shot. He was only shot by one. Okay, so this is the kind of context in which risk contribution occurs in. I was finally able to find a case back from 1801 called Schooner Peggy. In Schooner Peggy, there was a ship that had been seized at sea, and the case was tried, and the bounty of that ship was the subject of a judgment that was entered into court, and the case was pending on appeal. In the meantime, the United States entered into a treaty with France that changed the rules. Right? And the Supreme Court of the United States said, well, can we retroactively change the rules in this game that had already started? The whistle had been blown. A trial had been had, a judgment had been entered, the case was pending. And the court said yes, because it was a matter of national significance. But the court in Schooner Peggy put a note in there and said, when this is a question about private parties and adjusting private rights, you can't do this kind of thing. And you shouldn't do this kind of thing. And I searched high and low for a case, because this bill amounts to private legislation directed to benefit a set of specific parties in existing pending legislation. Right? And I know that my opponents, or at least some of my opponents, have been involved in helping to craft this bill. They don't like the way it went down in Chicago, perhaps. They're nervous, perhaps. I don't know what their thinking is. But they're not satisfied. And they're not satisfied with allowing the federal courts to rule. And so they come to you and they say, snap my fingers. Republicans in the state legislature, Scott Walker, governor of Wisconsin, we own you. Pass a bill, let us out of here. That's what's happening here. It's obnoxious, it's onerous, it's something that I could expect would happen in North Korea, not in the United States of America. You know, you need, all of you, when you vote on this bill, you need to look at these children in the eye and explain to them how you can change the rules for them in such a vile and un-American fashion. This is a bit, I know of no precedent for what you are trying to do here today. I'll answer any questions you have.
Thank you for your comments.